Okay. The charges stem from an incident that occurred during the early morning hours of April 14, 2013, in the area of the Mason Hall on Madison Avenue in the city of Albany. During the incident, I was alleged to have used the firearm to rob Marshall. That's his name. From here on out, let me refer to him as the victim. Is that cool?
Mm-hmm.
Okay. As he sat in his vehicle after exiting the Mason Hall Club. On April 14, 2013, the victim was at a party at the Mason Hall Club, which he left around 4 o'clock in the morning. There was a large crowd of people in and around the Mason Hall that night, and the area was well lit. Upon exiting the Mason Hall, the victim walked to his vehicle, opened the driver's side front door, and got into the driver's seat of his vehicle. As the victim sat in the driver's seat with the door still open, an individual approached the vehicle from behind the vehicle and stepped between the open door and the driver's seat where the victim was sitting. That individual then put a gun to the victim's head and instructed the victim to give it up. The victim complied with the assailant's request and handed over a chain he was wearing and bracelet and cash from his pocket. The assailant took the cash and jewelry and then reached into the victim's front jacket pocket and took his phone. Throughout the entire encounter, the assailant remained between an open vehicle door and the victim as he sat in the driver's seat. After taking his phone, the victim testified that the assailant took a few steps towards the back of the vehicle, away from the open door, such that the assailant was never positioned near the outside of the driver's door, where the door handle was. Now, I'm going to tell you exactly, in a minute, I'm going to tell you exactly why the door handle was so important. Okay, anyway, upon moving towards the rear of the vehicle, the assailant fired a shot that struck the back driver's side vehicle door. Now, there was this detective named Dean Hallpin. He testified that based on the angle of the bullet hole, he was confident that the assailant was standing in the vicinity of the rear door of his vehicle. The victim testified that the assailant fled towards the back of the vehicle after the shot was fired. After the assailant fired the shot, the victim closed the vehicle door, turned the vehicle around, and pursued the assailant for 1.5 blocks. The victim then noticed an Albany police cruiser, so he terminated his pursuit of the assailant and approached the police cruiser to tell the officer what happened. The officer was Patrol Lieutenant James Gallagher, who testified he was about 1.5 blocks from the crime scene when he encountered the victim. During his initial conversation with Lieutenant Gallagher, the victim described the assailant as a thin, Hispanic male in his 20s. At the time, appellant was a 38-year-old black male. Appellant being me. Okay, at the time, I was a 38-year-old black male, 5 feet 8 inches tall, 200 plus pounds. Lieutenant Gallagher testified that during his initial encounter with the victim, he noticed 2 small drops of blood on the door handle of the driver's vehicle. Lieutenant Gallagher also testified as to not having no direct knowledge of blood being associated with the crime. At the criminal trial, testimony from 2 New York State forensic investigators indicated that the 2 blood drops on the driver's door handle matched DNA of me. And that's only because my DNA was already in the data bank from prior convictions. No witness or trial exhibit provided any explanation of how the blood came to be on the door handle. The necklace that the victim gave the assailant was also recovered from the scene of the crime. The victim's testimony revealed he removed the chain himself and handed it to the assailant. The necklace was also submitted for DNA testing. However, no blood was found on the chain and no DNA could be pulled from the chain. The victim testified he did not observe any blood on the assailant's hand or dripping from him. The victim also testified there was no blood on his jacket, despite acknowledging that the assailant took his phone out of his front jacket pocket. From the outset of the criminal investigation, Jason R. Vogel, who was the lead detective in the case, and other Albany Police Department investigators involved with the case carried out a witch hunt and created a theory that the blood was left behind by the assailant. Case in point, a mere 5 days after the crime occurred, Detective Dean Halpin of the Albany Police Department Forensic Unit, who arrived at the crime scene on the date of incident, secured a sample of blood that was located under the vehicle door handle of the victim's vehicle. There was absolutely no evidence to support that this sample of blood was even associated with the assailant. On April 19, 2013, this blood sample was received by the New York State Police Forensic Investigation Center to be searched for a match in the New York DNA index system, also known as DIS. The description of events given on the New York State Police Laboratory Evidence Submission Form states as follows. S, which stands for suspect, was cut during the crime. Blood drops were located under the driver's door handle. That was a quote. Now, this evidence submission form was prepared and submitted by Detective Dean Halpin, who worked alongside Jason R. Vogel in the investigation. However, at the criminal trial, Detective Dean Halpin, under cross-examination by my trial attorney, gave the following testimony. Question. Just one further question, Detective. You have no direct knowledge of how that drop of blood got on there or when that drop of blood got on there, correct? Answer. I do not have any direct knowledge, no. Question. And you have no direct knowledge that the drop of blood had anything to do with the robbery that happened, correct? Answer. Correct. The victim's initial statement given to the Albany Police Department on the date of incident made no mention of blood being involved with the robbery. The victim also gave a complete description of the assailant as being a Hispanic male, about 25 years of age, 5'7" tall, with a small build. Another witness by the name of Patricia Harvey, who was also at the crime scene, gave a statement to the Albany Police Department that she saw a young Hispanic male running away from the crime scene. On May 9, 2013, the victim sent Detective Jason R. Vogel a photograph of another male, stating that the individual in the photograph, quote, looked about 90% like the kid that took my stuff and shot at me, unquote. The photograph was of a 17-year-old who was arrested for 2 armed robberies that occurred in East Greenbush on April 12 and 13, 2013. According to detectives Jason R. Vogel's testimony given at the criminal trial, when a DNA lab report came back in September 2013 with an affirmative match to my DNA type, he created a photo array that included a photo of me. And on October 2nd, 2013, this photo array was presented to the victim to make it possible identification of the assailant. Now, this unduly suggestive photo array depicted 6 black males, despite the victim and witness, Patricia Harvey, describing the assailant as being a young Hispanic male. Not one Hispanic male was placed in the photo array. Not surprisingly, the victim was unable to identify anyone in the photo array as the assailant. Initially, the ADA affirms under the penalty of perjury that the criminal case was initiated by the filing of a felony complaint. Subsequently, an Albany County grand jury returned an indictment. I had that document as well, bro. Appellate requested numerous times during the civil discovery phase to be furnished with a copy of such document, but was eventually told by way of an attorney affidavit that such document allegedly did not exist. The criminal record is completely devoid of a felony complaint accusing the appellate of committing said charged crimes. which indicates that the grand jury was not submitted with the proper evidence on the basis of a felony complaint that's pursuant to Criminal Procedure Law 190.55 2A. Similarly, the ADA, the district attorney, for those who don't know, what ADA is an assistant district attorney, for the first time during the civil trial is alleged to have proceeded with the arrest, indictment, and prosecution, and not Detective Jason R. Vogel, which the district attorney, which the district court agreed with. However, if true, the entire proceeding would not be devoid of a superior court information in the form of a written accusation filed in the superior court pursuant to CPL 200.15, charging the appellant with the commission of said charged crimes. I'm not going to go too much into it. I only got a little bit left that I want to fill in. All right, anyway. The criminal trial was held on September 8th and 9th, 2014. The jury ultimately found the appellant guilty on all 3 counts submitted to the jury. The criminal use of a firearm count was dismissed prior to the commencement of the trial. Prior to me being sentenced, my lawyer, trial lawyer, Rebecca Brosher, submitted a motion to the trial court requesting to have the verdict set aside. Upon the grounds that the evidence produced at trial was insufficient and inadequate as a matter of law to prove guilt beyond a reasonable doubt, appellant's motion to set aside verdict was denied. I got all these documents I speak of, bro. At the conclusion of the sentencing hearing held on November 17, 2014, on my birthday, on my motherfucking birthday, appellant was thereafter sentenced as a second-time violent offender to an aggravated prison term of 23 years, followed by 5 years of post-release supervision. I then filed a notice of appeal. On February 23, 2017, the Appellate Division of the Supreme Court 3rd Department reversed the conviction and vacated sentence in my criminal proceeding. We made the matter back to the Albany County Court for the trial. On April 20, 2017, our criminal trial attorney submitted an affirmation on behalf of me to the Albany County Court requesting that the indictment be dismissed. In turn, on August 16, 2017, my daughter's birthday, the ADA filed a motion to the Albany County Court requesting that the indictment be dismissed on the merits. On July 9, 2018, I then commenced the civil rights action in the Northern District Court of New York. And that's just a description as to what happened. Now, bro, if you got any questions for me, something that you think I should fill in, just feel free to ask me, bro.
Do you think, like, it was a lie that your blood was found on the scene from the gate, or what?
All right, here's the thing with that. Even if my blood was found there was never no knowledge as to why it was there, how it got there, or when it got there. There's 1,001 ways and 1,001 reasons why it could have been there. The car's parked on the public street. And then not only that, but my blood had a right to be. It's not illegal for my blood to be on someone's car. Not a crime. Now, it's deep that you say that, man. It's deep that you touch on that point right there. Because of course it looks circumstantial.
For the record, it's a million motherfuckers in jail. Niggas got sentenced to death for shit that they didn't do. So the law is the law. Like, it ain't about whether or not you did the crime. It's whether or not they can prove that you did the crime. The same way, if they feel they could prove you did it, they'll give you 100 years. This is why we have a trial. You understand? Because not only do I have the right to a fair trial, but you don't know the circumstances of what may have happened that night that I don't want to speak on. but I didn't actually rob that dude or whatever, and you might send an innocent man to jail for 100 years. You feel what I'm saying? So at the end of the day, in the court of law, because I'm into law, so in the court of law, it's about what you could prove. It ain't about what actually took place, about what you can prove to send a man to jail. You feel what I'm saying?
Yes. Yes, you're right. And you know, what I'm looking for, which was very important, right? Okay, you know, there's three forms of reversals. There's a reversal modification, where they knock off some of your time. Then you got the reversal, brand new trial. And then you got the reversal that dismisses the indictment and total. I was hit with the reversal and granted a new trial. All right. Now, the reason why is because, and I'm looking for my case now, because you know that's documented forever. You can pull it up and shit like that, and you can see it for yourself. I think my wife said she sent it too. They should have dismissed the entire indictment. It should have been dismissed, and the reason why it should have been dismissed because the Court of Appeals in New York State already made a ruling on such type thing, and the appellate courts basically reiterated that same ruling. Simply because someone is present at the scene of a crime around the time, the commencement of the crime, does not identify them as the perpetrator. I was never even supposed to be charged for that crime simply because my blood was found on the car, because New York State Court of Appeals already stated that simply because someone is at the scene of a crime without more does not mean he's the perpetrator of the crime. You need more.
And even if your blood was on the car,
that's right,
it could have been a situation that happened the night before where you got into a fight with that dude or whatever, and a drop of blood was on the joint. That don't mean you was a nigga who happened to rob him.
Yes, I could have got into a fight with anybody. I could have been driving by in my car and noticed that I had a cut on my hand or my arm or some shit like that. I had my shit out the window so it won't drip in my car, and maybe it hit his car. His car parked on a public street. So it wasn't illegal for my blood to beat it. And you know, anytime New York Court of Appeals make a ruling, you should know this because you know law. It becomes law in New York State. They've been had touched on it, so you know, lawfully I was never supposed to even be charged with the crime. Because they're saying because my blood was on the car, I committed the crime. But they had nothing else to verify it. And the courts already had said a long time ago, the Court of Appeals made it law in New York State simply because someone is at the scene of a crime, at the time a crime happened, does not make him the perpetrator alone. You need to be able to corroborate that. So I was never supposed to even be charged with the crime. It was already law that you needed more to that. So now look how they try to bluff me, right? So I get the reversal, right, bro? March 30th, I goes back down to court. So you know, before you go out to see the judge, you usually meet in the back with your lawyer and shit like that. So I'm sitting down with the same trial lawyer, Rebecca Brosher. So I gets up in there. Now, mind you, I already know I got the case because it's printed. It's on the computer. You know, they got computers in the pen now. You know what I'm saying? It ain't just typewriters and books and shit. Niggas don't even use books. Them shit's obsolete now. Everything is on the computer. All the jails got them now. But anyway, I already had printed the case out. I had the case. I brought it with me and everything. So I gets in the back with my lawyers. So I sits down with her. I'm like, yo, Rebecca, what's up, man? You know, I'm feeling happy. I could tell she's feeling a little happy. But at the same time, she never really believed me. She never believed me from day one. But anyway, like, what's up? She said, listen, said Judge Breslin, man, he got an offer for you. I felt that kind of like baffled me because I'm like, Judge Bresnan got an offer for me. Judges never give offers. That's usually the prosecutor that do that. So anyway, being that I got one of his cases reversed, he took that personally. All judges hate that when their cases get reversed. All right, but anyway, I said okay. So now I'm playing, you know, the school set by the door. So I'm like, okay, all right, what's his offer? But I already knew they couldn't take me back to trial because the only thing that they had to get that conviction on, when the appellate courts reversed my shit, they threw that out by making that statement. Simply because a person is at the scene of the crime around the time the crime happened does not make them the perpetrator alone. So I already knew they couldn't take me back to trial. But I knew, okay, all right, I said the bluff is on. They're gonna try to get me to cop out to something. I got the victim's initial statement. I got his initial statement. The victim came to trial. He got on the stand. He testified. But he gave what's called testimonial evidence. Testimonial evidence is just basically telling the story as to what happened to you. Not one time did he point the finger at me and say, that's the guy sitting there, man, who committed a crime against me.
Did that dude get on the stand and say that it was a young Latin dude again on the stand?
Yes.
They didn't say, yo, does this look like the dude who robbed you?
Listen, now you know they love asking that question.
But they didn't?
What was so weird about it, the DA didn't ask, neither did my lawyer. And I kept, now look, this is where I didn't understand law too well. I kept tapping her, like asking the question because the DA went ask him. And she leaned over and she whispered in my ear, listen, lawyer one-on-one, you never ask a witness a question like that. Just leave it like it is. If he's not saying nothing, leave it like that because there's no telling what he might say if I ask that question. And she was right.
Word.
I didn't know no better at the time. But to answer your question, Laz, yeah, the DA did not ask him that question. Do anybody in this courtroom resemble or look like the person who robbed you?
That's very suspicious.
Yes. So in essence, from the very beginning, this dude never told on me. He just spoke about as to what happened to him that day when he left her. And he didn't even want to do that, but you know, they put pressure on the nigga to show up. Now check it though, right? Being that we talking about this part of it too. After the reversal, my lawyer sends a private investigator to go talk to him and ask him would he be willing to testify at the second trial. Now look, the private investigator, his name is Kevin Conley. Good private investigator too. He goes to see him. And when he tells him why he's there, the dude who saw him, the victim, stops him and said, listen, I heard that guy got convicted of robbery. I never said that guy robbed me. That's not the guy who robbed me. So the private investigator, he fucked up. He's like, hold up. Would you be willing to give me a statement saying that? He said, yeah. I got the statement right here, bro.
That's crazy, right, bro. That nigga a super private investigator for getting that statement for you.
Listen, and not only did he just get the statement from me, right? But he recorded the whole joint. He had the glasses on with the camera in it.
Oh, man, that nigga is the truth, bro.
Yo, I still got his card, bro.
I need his card. I need to have his card on deck just in case.
Listen, bro. Let me read this for the record right here, right? The statement that he gave to him. Let me just read this for the record, bro. I been duly sworn, deposes and say I am 45 years old and I work at the boxing center in Albany. I go by the name of Back on April 14, 2013, at about 4 o'clock in the morning, I was robbed. I had some jewelry, money, and a cell phone taken from me. The guy who robbed me was a thinner, younger kid who looked Spanish to me. I took my jewelry off and gave it to the guy. He did not rip any jewelry off my neck. In November 2014, I had the opportunity to see the guy who had been arrested for robbery, Stephen James. When I saw Stephen James, he looked too big and too old to be the guy who robbed me. What I mean is that Stephen James was heavier and older than the guy who robbed me. As a professional boxer, I am good at looking at someone and knowing their height and weight. Mr. James was not the guy who robbed me back on April 14, 2013. I have given this statement to Investor Kevin Conley of my own free will, with no threats or promises made to me. I do know how to read and write English language. I have read this statement and I swear under the penalty of perjury that these words are the truth. And he signed off on it, bro. That was mate right there.
So at this time, you was in the can for this robbery, convicted in the can, and you had no idea that this dude was gonna acquire that statement?
No.
When did you hear that he got that statement?
All right, hold up. Now, the reason why my hopes was so high because no one ever identified me as the assailant in the crime. No one. I thought I was gonna walk at trial. Now look, the only reason I ended up with that statement, I got that statement after the fact, after I got the reversal. Now mind you, he never said I did nothing to him from the very beginning.
So with your reversal, you came home?
No.
You had to stay in the can and just wait for a new trial?
Yeah. Now mind you, I had 2 other cases. Remember, I was telling you in the very beginning, I had the assault case and I had the robbery case. Now, I had to cop out the 5 years for the assault case and the same thing for the gun case. And they ran them consecutive. So when I got to 23 years, they ran that consecutive. That's how I ended up with 33 years. So when I got the 23 knocked off, that left me with 10. So I did 8.5 out the 10, which is what you do on your CR. That's how I made it home in August.
That's crazy, bro. That's crazy. So what? So who found out? Who did he contact first when he got that statement from that dude?
All right, my lawyer, because my lawyer the one who sent them out. Now, mind you, she didn't send them at him to get a statement from him saying that. She sent the private investigator at him to see whether or not he'd be willing to testify again at a second trial. Because I had got the reversal and I had got granted a new trial. So that was the whole purpose of sending the private investigator at him that time. So now, mind you, I'm laying up in Albany County Jail. Now look, let me go forward a little bit because I started telling you about what happened after I got the reversal and I came back down. All right, so I told you I met up with my lawyer before I actually went out there to see the judge, right? So I'm like, yo, Rebecca, what's going on? How you doing? And, you know, small talk or whatever. Yeah, boom, boom, boom. She acting like she happy. I'm happy because I got a reversal, so I'm back down, you know. And I already know that they can't take me to trial again because that little piece that they used to get a conviction, it was tossed by the appellate courts once they reversed my shit. This is why I don't know why they ain't just dismissed the indictment. But anyway, they was giving them a shot at me. This is the game these crackers play, though, man, lads. They was giving them a shot at me. They thought I was going to be the dummy. They thought I wasn't going to be the wiser and jump on an offer, scared to death for that 23 and jump on anything, just so I don't have to do 23. I told them niggas to eat a dick, nigga. I swear to God, lads. So now, hold up, lads. Back just a little bit. So now I'm talking to my lawyer. So she said, Judge Breslin, man, got an offer for you. I said, oh yeah? I found that odd because judges don't give offers. That comes from the prosecutor. So I said, oh yeah? She's like, yeah. I said, okay, what's the offer? I said, now I'm going to play the spook was set by the door. I said, what's the offer? Said, oh, it's a blind offer. I said, what the fuck is that? It gotta be more than 5 years, and they gotta run consecutive to your other 2 sentences. I said, come on, brother, man, why would I do that? And then that's when I pulled the case. I said, you didn't read this part right here? They can't take me back to trial. All right? So she tried to act like she didn't understand what the fuck the law was saying.
Who, your own lawyer?
My own lawyer. And you know why? Usually when a lawyer don't believe you, when they believe you're guilty, they don't want to fight as hard. Now, she's really the reason why I got the reversal. This is what baffled me.
She was a private lawyer? She was a private lawyer?
No, she was appointed to me.
Oh, man.
She was appointed to me. But what was so crazy about the whole situation, like, it's like she was playing a fence. She got me the reversal, bro. Look, I knew nothing about the difference between circumstantial evidence and direct evidence. I knew nothing about the difference. She knew that my entire case was based on circumstantial evidence, and it was. The blood being on the car. Now they have to piece together a circumstantial evidence case. They have to be able to, corroborate certain shit with certain shit so that it could fit like a puzzle. It's indirect evidence. Now, my entire case was based on circumstantial evidence. She explained all this to me, but at the time, I don't know this shit. I don't give a fuck about that. I want to go home. I ain't do this shit. Ain't nobody said I did nothing. I'm going home. I want to beat this shit. But what she was doing, she knew that I wasn't going to make it out of there. She knew they was going to convict me. So what she wanted to do was preserve the strongest issue possible, and she did. She preserved the circumstance. So during the trial, she asked for an entire circumstantial evidence charge to be given to the jury. An entire circumstantial evidence charge is the same thing as instructions to be given to the jury. If you have an entire circumstantial evidence case, right, and this is with anybody, then your lawyer can object and say, Judge, listen, I want the jury to be read the entire circumstantial evidence charge, which is an instruction. Same thing. It's just, it's just legal terms, charge, instruction. It's the same thing. All right. But anyway, that's what it's really known as, a charge when you at trial and you want the jury to be read a certain instruction. And that's very, very important, right, during anybody trial. Okay. Well, anyway, the judge denied it, but we preserved it. Now, the fact that he didn't do that automatically, that's a reversible error. That's how I got the reversal, bro. And when I went up north with it, she gave me the Sanchez case, which was a New York Court of Appeals case that set the standards for that issue. And when I went up north with that sort of mother, man, I just perfected it, homie. I looked everywhere. I went in every court with that same issue, and everywhere was saying the same thing. So I knew I was going to get a reversal. It was a fact. It's an automatic reversible error. If you ask for a particular charge that fits your case, and the judge denies it, like in my case, I asked for the entire circumstantial evidence charge to be given to the jury, and he denied it, automatically it's a reversible error. And that's what happened. That's how I got the reversal.
That's crazy, bro. That's wild. You was on top of your motherfucking grind to get that shit happen.
I was, bro, and it really gave me the confidence, man. Like, this is why I'm not out here in the streets and I'm not ripping and running and I'm not doing this, that, and the third, man. I'm working, and I was able to accomplish a lot with the help of my family, with the help of my people. I was able to accomplish a lot, but this is why I'm not ripping and running, because it gave me so much confidence that, Steve, you can do whatever, my nigga.
But after you have a brush with your life like that, because that's your life, 33 years, 23 years, after that your life is over. So it's like, after you was given even though you shouldn't have been charged in the first place, but when you missed motherfucking being in the penitentiary for that long by this much, you gotta take that shit as a forever blessing to never put yourself in that situation again, my bro, because it's like then the universe ain't gonna have no remorse for you. It's gonna be like, yo, you beat that case, you went home, you feel what I'm saying? You could have had lights out then. And you went home, now you playing around in the streets again. Alright, now I'm really turn your lights out. That's how I would feel the universe will deal with you. You feel what I'm saying?
My nigga, you know they waiting for me to slip up, homie. They waiting. And they in the cut with it too. They real quiet. P.O. don't be on my back enough. And look, they trying to give me enough rope to hang myself, homie. P.O. don't fuck with me enough. But you think that broad don't know what the fuck going on? She know what the fuck going on. She know what happened. They all know what happened. They real close-knit family up here in Albany, yo. They all in the bed together, man. And they hold each other down, yo. They risk their careers, man, to save you. One of their own, yo. That's how they on it.
Mm-hmm.
That's how they on it up here, yo. And I didn't realize that until my lady, like, put me on when we first got together. She was like, yo, she said, yo, this is a racist town up here. I didn't see it. I didn't see it until I started fucking with the court system up here.
Yeah, nah, they turn your lights out, especially knowing that you from Brooklyn and you up there, they'll turn your lights out up there. Real talk,
but they did though, bro. That's the thing, my nigga.